A federal judge is holding a hearing on whether to deport Kilmar Abrego Garcia to another country. The Trump administration said it mistakenly deported Abrego Garcia to a notorious El Salvador prison in March. The government then brought him back to the U.S. to face human trafficking charges, which he pleaded not guilty to. And now the government's trying to deport him again, possibly to Uganda or Eswatini. Immigration attorney Frank Symphorien-Saavedra is here for more on that. Frank, thank you for coming on. So the administration is asking to delay all deadlines in this case due to the government shutdown. Abrego Garcia's attorneys say that shows it's unlikely he'll be deported in the foreseeable future. So how do you see this playing out?
Well, it's actually quite ironic that the government's position in this case, essentially in having him removed, gave rise to his asylum claim. The fact that usually he previously was denied asylum because he didn't file within 1 year of his arrival. But the government's speed and haste in moving him to El Salvador without any means of due process essentially gave him a second opportunity to request asylum from El Salvador. And arguably, it also provided some real substantial grounds for that, given that we don't have any information on the circumstances of his detention in El Salvador. He alleges that he was subject to torture and beatings and so forth. And so it's quite ironic that the government's own removal of him to El Salvador gave rise to his asylum claim. And I think it's quite a compelling case on the surface. Obviously, we'll have to see how it plays out in court. But I think it probably prevents the government and is likely to give him a significant ground to prevail on these attempts to remove him to a third country.
This comes after the judge denied Abrego Garcia's motion to reopen his original immigration case and seek asylum in the U.S. So how unusual is it for an immigrant to be deported somewhere so far from their native country? And what does this judge need to consider?
Extremely rare. I mean, in 18 years of practicing law, I've never seen a person removed to a third country. It's one of those things that, you used to read about in law books, but never really actually occurred. Unfortunately, this judge is supposed to follow the law and is supposed to consider his fears of going back to El Salvador. With regards to Uganda, because it's so rare, there's not a lot of principles in law. There's not a lot of precedents to follow. But I do think there's a significant issue here that the court needs to consider with regards to his removal to El Salvador, again, because that gave rise to a new claim of asylum and allows him to seek protection regardless of any other country that offers him an opportunity to go there. So I think the court has to grapple with that issue. Did he file for, was he actually executed the prior removal order? Because essentially when the government removed him, it essentially ended that prior proceeding, in my view, and it allowed him to file a new asylum application. And so although the court denied the case, obviously this is an administrative court that is an appointee by the president. So it's not surprising that the court would deny his claim to reopen the case. But I do think when the case eventually gets up to the circuit courts, I think he's going to have a significant opportunity there to reassert his asylum claim anew, and perhaps to have his case reopened and considered based on the circumstances of his removal to El Salvador.
And later this week, another judge is set to hear arguments on whether or not the government engaged in a vindictive prosecution in the human trafficking case against Abrego Garcia. What are you watching for there?
Well, it's quite surprising in some ways because the standard is so onerous on defendants that seek to raise this vindictive prosecution standard. But what is, again, ironic here is that the government, the court, the defendants are using the government's own statements, Todd Blanche statements in regards to the reasons why they initiated this prosecution immediately when the district court judge in Maryland granted a stay or required the government to bring him back, prompted the initiation of this criminal proceeding for a case from 2022 that was long forgotten, was dead, and really had no reasons to come to life again, but for the proceeding in Maryland. So I'm looking for the government's testimony as to how they intend to, attack or respond to the defendant's significant arguments that this is the only reason this case came forward, and that is because Judge Zinnes required the government to bring him back. And but for that action, this proceeding would never happen. And it's funny because it's actually the government's own statements. Todd Blanche statement in a public statement, which usually you don't have administrations publicly commenting on pending matters. And this is probably the reason why. This is a good example why you should probably, it's unwise to comment publicly on pending cases. And so I look forward to seeing how the government was going to respond. There's probably going to be depositions. There's going to be a discovery. There's going to be probably a significant hearing. Is Todd Blanche going to testify? Is the government going to exert executive privilege, preventing him from testifying? And additionally, is the government attorney for the district court that refused to bring forward these charges and resign, will he be required to testify? That's going to be quite interesting to see to what extent, the government the defendants are able to get that additional testimony supporting their grounds for the selective prosecution and dismissal of this case.
Frank Symphorien-Saavedra, we appreciate it as always. Thank you.
My pleasure.